This video explores the objective, data-driven story of how the law regarding physical discipline of children in Aotearoa, New Zealand changed and the measurable impact it had on families. Historically, pre-colonial Aotearoa did not subject children to physical discipline, viewing them as taonga or treasures. This clashed with the British colonial influence, which imported the, quote, spare the rod philosophy and the belief that physical discipline was necessary for order. The legal change was gradual. The 1893 Criminal Code Act formalized reasonable force for correction. Over the next century, corporal punishment was slowly abolished, culminating in the 2007 Crimes Amendment Act, which removed the, quote, reasonable force defense for parental correction. New Zealand became the 19th nation and the first English-speaking nation to ban physical punishment in 2007. This was decades after Sweden, the first to act in 1979. Today, 74 countries and territories have followed suit. The 2007 amendment removed a key loophole in the Crimes Act of 1961. Before 2007, the law allowed parents to use force if it was deemed, quote, reasonable. The new law explicitly stated that force cannot be used for the purpose of correction. The 2009 referendum showed the deep emotional division. The loaded question, should a smack as part of good parental correction be a criminal offense in New Zealand, focused on fear and the perception of state intrusion into family life. Two mindsets emerged. One views smacking on a continuum of violence, focusing on child socialization and the state as a protector. The other sees minor smacking as separate from abuse, focusing on parental authority and tradition. The law codified a social change already underway. Parental endorsement of physical punishment dropped from around 90% in the early 1980s to 58% by 2007, falling to about 41% by 2019. The fear was that good parents would be criminalized for light smacking. The fact, based on the 2009 Ministry of Social Development review, was that there was no evidence of unnecessary state intervention for occasional light smacking. The law built in a common-sense buffer. Police are explicitly directed not to prosecute trivial cases. If an offense is inconsequential and there is no public interest in prosecution, police apply discretion and offer a warning or support. In the 2 years following the act, only 14 prosecutions occurred under the, quote, minor acts of physical discipline category. The review showed these cases were serious, involving children slapped in the face or hit multiple times, not light smacking. A spike in child welfare notifications after 2007 was driven by police training on family violence and the It's Not Okay public awareness campaign, which increased reporting. Substantiated cases of physical abuse remained flat. Despite the law change, a minority of parents still use physical punishment. The Christchurch Health study shows 77% of parents at age 25 reported using it, dropping to 42% by age 40. Physical punishment rates are higher for young children and disproportionately utilized in Pacific communities, with rates 2.1, 4 times higher than non-Pacific rates. These disparities show where community outreach and parental support must focus. The journey is now from punishment to support. The 2007 law declared children deserve the same legal protection as adults. Programs like SKIP, Strategies with Kids, Information for Parents, help equip families with alternatives to physical force.